now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give an direction to the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Kindiki, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that Mr. Ongoya applying for an adjournment? Because he's saying, and perhaps rightly or wrongly, that even the recusal application comes after the termination of the question of empanelment. If that be so, they may leave, they normally leave court, they may leave, they left Senate, may leave court. We let them say whether they are applying for adjournment.
Is that the mark they normally leave court, whether the Senate might palatable in this court, my lord? I need that.
No, because it's an adjournment.
No, is that the mark palatable before my lord, my lady? But because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, I'm urging that you accept that remark to be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem with withdrawing the remark, but the point is, it is a veiled application for adjournment. Because Mr. Ongoya is saying that the court must address the question of empanelment before the recusal. So why can't he just get to the point?
I'm answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I did withdraw. I wanted to withdraw first, my lord, because I'm entitled to dignity.
I have no problem withdrawing. Okay, my friend. No, I have no problem, my lord. I withdraw the remark, but there is practice.
Thank you. Let me now address the question. My lord, because again, I was my teacher and the mentor of many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Kido Mungai, and learned colleague, Mr. Gachagua, that we now want to take that on an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. Is therefore in that request that my Lord Judge asked, how do we move forward? I also had my learned mentor, Professor Kindiki, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I have it.
Lordship, again, we're about to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this page was empowered has not come to light, which is now. They actually knew of it, and this, or should have, they would have found out. The letter, which was written this morning, which we have, it was received on it was written on the 20th of October, has actually one pertinent question to pose: whether the file was actually taken to the Chief Justice and at what time. So, they are actually knowing something regarding that. Then we are dealing with constitutional functions, under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of a Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work. Which, and here, let's not reverse what we were told. That as we do in Parliament, you go around in circles to waste time so that the motion possibly is defeated by evolution of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard?
Yes.
My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleague, the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add.
This court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.